Okay, folks, so I want to talk about the term paper in a little bit more detail. Apologies for the delay. It took me a little sec to get a microphone and get set up here. I am screencast recording this, so the video you'll see up there, the QuickTime thing is going. Let me hide that. What I'm doing on the screen here is being recorded, and the audio is what's coming on through the microphone. So you'll be able to watch what we talk about now again at your leisure. I was joking with the folks in Peter Jackson's office downstairs that this is another part of the class where I'm trying to cram law school in around the margins. And it's a really difficult thing. It's a really important part of what makes this class so challenging is that we really are trying to do this. We're trying, you know, if I was teaching this as a second, third year law school class, I could say, well, you all know how to do research, you all know how to write a legal paper, go, right? But the vast majority of you have zero exposure to that, and even those of you who have a little bit of exposure, you're still gonna need, appreciate a little bit of guidance. So that's what we're gonna focus on today is the paper. Again, I'll post some content that's more specific to the readings and what's on the syllabus for now. In the very near future, but in the meantime, I just want to make sure we're talking about the paper in class in some detail. Now, a few of you have submitted your topics. I now have one bibliography, which in principle was due today. No, that's due next week. I take that back. The bibliography is due next week. So, in principle, I have one who, I have a few people who've picked a topic. That is something I'd really like to chase you towards. If you haven't picked a topic yet, really start reading those 6 cases. Just read through them. You don't have to read them like your life depends on it. You don't have to read them like they're going to be on the final exam. They will not be on the final exam. You only have to pick one of them. But make sure you're making an informed choice. Look through them in some detail and pick a topic as soon as humanly possible. And then what I want you to do is, and what I want you to do with those cases, of those 6 suggested cases or something like them, another case that's not on the list is totally fine too, although certainly run it by me, is the point here is not merely doing the paperwork and getting that into me, but so that you can get started. If you take the time to get started on your paper now, you will actually get a lot more out of writing your paper, and it will be a much more enjoyable process. I promise you. I've written a lot of papers the night before. It's no fun, and the product is bad. The product is terrible, right, relative to what you can actually do. And you can do better than that, so do better than that. Let's get started. Let's get our papers in. Let's get our topics in. Let's start doing bibliographies and doing research. So I want to just go over again real quickly how to do, not watch basketball on television, but how to do the case research and what I want you to be doing here. Does anyone have the paper? You know what? Actually, no. I've got it pulled up here. Anybody have a preference among these 6 suggested cases? Say, I really want to look up the Bill Graham case, or I really want to look up the Ariba case. Any strong preferences for where we want to go? Ariba. Okay. So tell us a little bit more about the Kelly v. Ariba case. We already started to cover this.
It was, can't remember off the top of my head. It's a case where she has, I think, the database of thumbnails, where I forgot what the use was for.
Sure. It's an early version of what we now know as Google Images or Bing Images, right? It's an image database that on the web that indexes images that are available online, so that we can find relevant images. And the way we find this out is not by being psychic, is not by knowing a whole lot, but instead we select just this number here. Oh, this color's not coming through very well. 336 F.3D 811 is what I'm highlighting here. I don't know how clear that is. Right. So I've highlighted that. I'm going to copy it, Command-C on a Mac, Control-C on a PC, of course, and go over to LexisNexis. Now remember, for the product sign-in, you're going to choose Academic. And then you don't have to go any deeper than the landing page to look this case up. You just right here in the by citation box, right? And it even has an example that should make you ring a bell, like 347 US 483. Oh, I know what that looks like. And I therefore know the citation in my case. I'm going to find that. I'm going to copy it. I'm going to paste it. Command V on a Mac, Control V on a PC. 336 f.3d 811. You hit go. And it should be the second one, the 2001 case. Yes. Okay. There we go. And it's got, now again, remember, when it comes up here, it's got all this stuff at the top, a lot of it in bold, a lot of it highlights, a lot of it hyperlinks, you know, 5 different ways to cite the case, procedural posture, disposition, prior history. None of this stuff is really of interest to you. None of this stuff is really of interest to you. I kind of sort of know how to use some of these things. I mean, that's an oversimplification, but that, you know, like I know what I'm looking for in this stuff, and I still basically just say, maybe I'll look at the overview briefly, because this is usually a fairly faithful summary. If I have no idea what the case is about, I might look at the overview, but for the most part, just skip through the head notes, which is, you know, skip past the counsel or attorneys, judge's opinion by, and finally, in big bold letters right there, opinion. Opinion. The opinion written by T.G. Nelson, the circuit judge. Is there a question? Now keep in mind that if you're looking at circuit court and Supreme Court cases, it's going to take more than one judge to form a majority. Right, district court, the basic trial court is just going to be one judge. But once you get to the circuit and the Supreme Court, then you talk about court majorities. That means there might be a minority, there might be a dissent. So be ready for, after the opinion of the majority, there can be a dissent that follows after. But what you're looking for is the opinion here, which is the opinion by the judges who formed the majority that decided how this case was going to come down. That decided how this case, that basically decided the case at the appeals level. And here we are, right at the very top, right? This case involves the application of copyright law to the vast world of the internet and internet search engines. The plaintiff, Leslie Kelly, is a professional photographer, yada yada. The defendant, AribaSoft, operates an internet search engine that displays its results in the form of small pictures rather than the more usual form of text. Ariba obtained its database of pictures by copying images from other websites. By clicking on one of these small images called thumbnails, the user can then view a large version of that same picture within the context of the Ariba webpage. Right? So that's you know, at a very basic level, this, when you skip straight down to the opinion, the judges are going to largely cut to the chase. I won't promise that they'll do it every time, but for the most part, judges like to talk about the facts of the case in a fairly summary fashion and just get it all on the table and start there. Now, when it comes to legal reasoning, then they go on and on and on and on and on, and that's that. At that point, your eyes might start to glaze over, and I wouldn't blame you. But and in terms of recounting the facts of the case, the opinion is a pretty good place to is actually a really good place to start, because they're just going to recount the facts in a very reporter who, what, where, when, why, you know, what happened sort of way. So Kelly discovers that his photographs are part of Ariba's search engine database. He sues. I know what the rest of this paragraph says. It says he sues, and then it goes through. It goes to a district court and it gets appealed. Right, and then you're going to see something here. 1, Roman numeral 1. And really what that means, and I haven't read this case specifically in a while, I'm not going to promise this, but I'm just fairly confident that after that Roman numeral, we're going to be largely done with telling the facts of the case, and we're going to be ready to get down to brass tacks of legal reasoning. Oh, wait, no. In this case, it's because the summary is so short, 1 is going to be the facts of the case here. Let's see. And then 2 is legal reasoning. I stand corrected. So sometimes the facts will just be part of the introduction, and they'll cover that in more detail. Salud. So you will notice that the reasoning. That the reasoning is going to be ordered differently than the way the paper is structured. You're going to notice that the reasoning is ordered differently than the way that the paper is structured. And I'm going to come back to the structure of that paper really quick because I want to really hammer home why it's organized that way and what I want you to start looking for, what I want you to do with it. But you're going to notice that these cases say that the law applies in this way because such and such, and the law applies in that way because such and such. And all of those arguments are going to be built upon previous law, existing law, largely existing case law. And who writes case law? Where do we get case law from? Which branch of the government gives us case law? The judiciary. The judiciary, which means other decisions that other judges have written before. That's going to be the primary thing that judges cite. That's going to be the strength of their argument, is can they find case law and other types of law that back up their argument. And that means that's largely how I'm going to be evaluating your paper. How well do you find existing law, largely case law, that supports the claims that you're making? Fair use factor 1A means this. Well, why does it mean that? How do we know that it means that? What's a persuasive legal argument that factor 1A means such and such? Well, if you can draw in a case or two or three previously where a judge specifically says fair use factor 1 subfactor A means such and such, and it applies in these types of circumstances and doesn't apply in these types of circumstances, well, then to the extent that you can make it look like your case is consistent with those conditions, lives up to the standards of that legal reasoning from the previous cases, the stronger your paper is going to be. The stronger your paper is going to be. That is how legal reasoning works. That is how legal reasoning works. Right. Which is that to make an argument based on the law, you have to argue what the law says. And the specifics of what the law says in most of these cases is going to be hashed out in the most detail in the case law. But you will notice that case law is not the only source of law that we draw upon. Where else do we get the law? Not just what other judges have said, but where else? What other types of law have we talked about? The Constitution, right? So if there's a constitutional argument to be made, you're going to want to cite the relevant section of the Constitution. I'm going to spoiler alert here. You're probably not going to be making constitutional arguments in your paper. That for you is a good thing. That for you is a good thing. The ability to make a good constitutional argument is something, as in a legal sense, is much harder than the ability to make a good basic case law argument. So we're gonna crawl before we run. So we've got constitutional law, we've got case law. What else? What other types of law have we not talked about yet so far today? Statutory law. Where do we get statutory law or statutes or code? Congress. Congress passes them with a majority in each house, and the president signs it, or the president vetoes it, and Congress overrides his veto with a 2/3 majority in each house. Right, this is Bill on Capitol Hill stuff. No, we're not. State law is a different level of law, and we would, at the state level, we would have the same sort of division. States have constitutions, states have legislatures, states have judiciaries, and all of those give different types of state law. We could look at that at the state level if we were doing a state legal issue. We're not doing a state issue because copyrights, for our purposes, exclusively a federal issue, and for in most cases is a federal issue. And the exceptions are not not important enough that we talk about them in this class. So we're interested in federal law, not state law. And we're interested in the federal constitution, the federal legislature, and the federal judiciary. We could probably take constitution off the table. right? So the judiciary and the legislature. This is which kind? Is this statutory law or case law right here? 17 U.S.C. Section 107. Statutory law. Congress gave us this. This is the Fair Use Clause in the Copyright Act of 1976. Right? Congress wrote and passed this. But it's really brief. It's really brief. Remember I told you go home, download that PDF, read sections 102, 106, 107? Right? And if you just read them through once, it takes you about 6 minutes. They're very brief. Section 107 actually fits on one page, which is a good trick for a statute. Like, that's not real common. But what that statute means, what that statutory language means as applied to specific circumstances is hashed out in incredible detail, in immense detail in the courts. In the courts. So when you're looking up a case, what you're looking at is a legal conclusion built on legal arguments. And legal arguments are built on laws. And we get laws from statutes and from courts, for the most part. So when you pull up this case, you're not looking at just something a judge wrote and saying, oh, well, who won? What you want to understand is the reasoning. What you want to understand is the argument. And to understand the argument, you have to understand how the judge draws in previous cases and draws in the language of the statute to reach conclusions. Right, so the judge's arguments are going to seem really natural if you don't look at the footnotes. If you don't look at the footnotes, let me give you an example of this. Of the judge's argument seeming really natural, like they just like it's just true, like it's the laws of mathematics. They're self-evident. Right? If you don't look at the footnotes, it just seems like what the judge is saying is, of course, that's self-evident. But all of the important arguments in a case are built on not that claim is self-evident, but that claim is consistent with what the Congress and the courts have already said in the closest cases, in the nearest circumstances that are most closely resemble the circumstances that are before the court today. So let me give you an example of this. So you'll see. By the way, as you're reading this, you'll see footnotes and footnotes, footnotes and footnotes. And so that's. I hope that's reasonably self-explanatory. But let me just make super duper clear we're all on the same page, right? Between these lines, it's either the text of the case or the footnotes of the case, and it tells you when the footnotes have ended, and it's the text of the case, and then it's a break from the text of the case to tell you the footnotes for what that paragraph says. And so let's look at the text of the case without the footnotes real quick. A claim of copyright infringement is subject to certain statutory exceptions, including the fair use exception. Okay, we know this. The exception permits courts to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which the law is designed to foster. Now here we've got a quotation, so you know that comes from somewhere else. The statute sets out 4 factors to consider in determining whether the use in a particular case is fair use. We must balance these factors in light of the objectives of copyright law rather than view them as definitive or determinative tests. We now turn to the 4 fair use factors. Right? So all of that is stuff that I've said in class. All of that is stuff, phrased differently, more eloquently, right? But all of this is stuff that I've said in class. Repeatedly, right? But I don't say that in class because I have some sort of psychic connection with the copyright gods. I say this in class because me and a bunch of other people who know copyright a whole lot better than I do have studied what the cases say about fair use and what the statute says about fair use, and this is what fair use says. This is how fair use works. And we know this not because this is a judge who's read a lot and understands copyright law, but because each of these specific claims can be backed up by reference to either the statute or to a specific case. Right? So a claim of copyright infringement is subject to certain statutory exceptions, including the fair use exception. Right? So footnote 10. Footnote 10 tells us where that statutory fair use exception is, section 107. That's good legal writing. It helps the reader understand where that is, where that source comes from. The first time you cite fair use in your paper, you should cite that statute. You should cite that section, because that's good legal writing. This exception, quote, permits courts to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which that law is designed to foster, footnote 11. Then you look down footnote 11, it's a quote from Dr. Seuss Enterprises versus Penguin Books USA. By the way, this is also a very interesting case. It's about the cat not in the hat. It's a Dr. Seuss parody about O.J. Simpson. So, if you want to write that, you can actually write a fairly interesting paper about that case as well. The quotation is taken straight from that case. But even if it's a paraphrase, that sort of point, what I'm trying to get at here is what the judge is doing is saying, this is what fair use is for. It's to make sure that creativity isn't stifled by copyright law. And they've got a citation to back it up. That's how I want you to write. Now, I don't expect you to have a footnote and a citation for every sentence. That's how lawyers and law students write. We are not lawyers and law students. We don't have to hold ourselves up to that insanely OCD standard. And I promise you, they have an insanely OCD standard about the sky is blue, where's your footnote? Right? Like, it's very, they footnote everything. Right? So you don't have to do that. But do a lot of it. Do more of it than you think you need to. So that you're showing me how you're using your resources. And more importantly, you're showing me that there's solid legal evidence behind your claims. That there's a solid backing in the law for the interpretation of the law that you're arguing for. Right. The statute sets out 4 factors to consider in determining whether the use in a particular case is a fair use. They just put those 4 factors in footnote 12. And you know what, here, let me zoom in a little, see if this helps. Where'd we go? Right. The statute sets out 4 factors to consider in determining whether the use in a particular case is a fair use. Right? Yes. Yes, that's it. Clarity. There are 4 factors. I want you to tell me explicitly, there are 4 factors. And they are 1, 2, 3, 4. Now, they put that in a footnote. Don't put that in a footnote in your paper. Use that, frankly, use that to fill up some of your body. Like, give me more text than that. Right? To show me, answer, like, questions 15 through 18 on the midterm, that's your, answer that again right here in your paper. Because almost all of your papers are going to be fair use papers. 5 of the 6 suggested cases and virtually all the other cases people would pick are fair use cases. Tell me there are 4 use factors. Tell me what they are. Tell me what they look like. And as you break them down, give me some of this footnote citation-driven love. Give me some footnotes to say, factor 1B means blank, and what that really means is such and such. Here's a case that illustrates how that works. Factor 2A means such and such. Here's a case that illustrates how that works. So the first time you say fair use, you can basically say this, sets out 4 factors, and then lay out the 4 factors very briefly, and say, that this paper will explore each in some detail, and then not go into a lot of detail the first time you mention. But then when you break it down, I want you to really break it down. Tell me what each one really means. You will notice that in section 2, we've got a subsection A, which is about fair use, and then that is structured with a subsection 1, purpose and character of the use. This is a hint. You should structure your paper in a way that is this explicit. Now, if you want to have a bold headline that's set aside like this, it says purpose and character of the use, or you want to not do that because you think it looks clunky, either way is fine. But I want you to structure the discussion in order in a way that looks like this, that has the same organizational effect like this. Right. So when talking about purpose and character of the use, they immediately jump to, is it commercial or non-commercial? And say, the Supreme Court has rejected the proposition that a commercial use of the copyrighted material ends the inquiry under this factor. Footnote 14. That probably sounds familiar. In fact, by the way, I forgot to cover the extra credit question. A couple of you ran up to me afterwards and said, hey, what about the extra credit question? The extra credit question that's the answer to the extra credit question, right? The key change in Campbell versus Acuff Rose, after Campbell versus Acuff Rose, is relevant to factor 1, the first factor, and the commercial, non-commercial question. Which is to say, previous courts, including the courts under, the lower courts in that specific case, had held, many of the lower courts, the district and the circuit courts, had held that if it's commercial, that's pretty much the end of the fair use determination. That's pretty much the end of the fair use determination. There are 2 different ways to think about it, right? One is some said almost to the point where if it's commercial, it can't be fair use. But more commonly, courts said if it's commercial, it's probably not fair use. The technical terms there are dispositive and presumptive. I don't expect you to learn them. Dispositive meaning that that's it. That solves the disposition of this case. That's the answer to the question. If it's commercial, it's not fair use. That's the answer. That would be a dispositive ruling about commerciality being not fair use. That was pretty rare. Courts instead were much more likely to say it's presumptively not fair use. In other words, if it's commercial, it's probably not fair use. And the Campbell court, the Supreme Court in the Campbell case, that is, said wrong. Whether it's commercial or not commercial is just part of one of the 4 factors, and we have to weigh all of the parts of all of the factors under an equitable rule of reason. So the key change after Campbell was that they made super duper extra clear that just because a use is commercial, that doesn't mean it's not fair use. Right. And another important finding from Campbell. This was true before Campbell, but Campbell just made this even more clear, that the more transformative the new work, the less important the other factors, including commercialism, become. And again, we've got a citation down to Campbell. Id. By the way, when you're reading cases in footnotes, id means the last thing I just said. So footnote 14 is Campbell versus Acuff Rose, and footnote 15, id, says Campbell versus Acuff Rose. Footnote 16, id, still Campbell versus Acuff Rose.
We're doing that in our paper too.
You are welcome to do this in your paper if you use footnotes. You don't have to use footnotes in your paper, by the way. You're welcome to do MLA. You're really welcome to use MLA. That's fine. As we get closer to the, not the organization and planning and structuring, but actually writing your paper, we'll talk a little bit in class about how to do MLA citations of legal materials. It's not as clean, it's not as easy as footnotes, but it's a lot easier than learning a new citation style. So I'd rather have you just use MLA if that's what you're comfortable with. But if you are using footnotes, id is fine. There is no such thing as id in MLA. But what MLA allows you to do actually is instead of saying id with repeated footnotes, you can just keep saying, so you could just say, here, which you'd have an in-text citation in parentheses after the paragraph, after the extended quotation. And then in this sentence, you would just add in, the Campbell court further told us that the more transformative the newer. And then you just use that sort of in-text citation, but in-sentence citation style to just let me know you're still talking about the Campbell court. And to the extent that you're still drawing on that opinion, you should definitely do that. Let me know that you're still citing it, because I really, really like it, and readers in general really, really like it when you've shown that you've really done your homework. You've really thought about how each specific thing that you're citing comes into play. So. Is it?
It's over there already in the corner.
Yeah. Was it a rat or was it just a mouse?
No, it's a rat.
A rat? Really?
Yeah.
Wow.
It's black, so yeah.
Really? The mice aren't black? I didn't know that.
Black.
Oh, okay. Wow. Yeah, pick your bags up off the floor, folks. Let's not take the rodents home with us.
Compared to subway rats, it's small.
Oh, no. Yeah, absolutely.
Compared to subway rats, small. So.
Everyone picked up their bags, but they didn't come. They just ran across the wall.
Yeah.
But it's like the reaction is there's some wave that everyone picks up their bags instantly.
Yeah. Well, better safe than sorry. Let's leave the rodents here. So, it's always hard to transition out of rodents. so it should be utterly unsurprising to you that federal circuit court judges are models of legal reasoning and writing. Of course they are. Of course they are. That's really, that's something, if you say, well, who really knows a lot about the law and how to write about it and how to research it? Well, the people who determine it obviously should be at the very top of the list. And really they are. Really they are. Especially by the time you get to the circuit court, let alone the Supreme Court, some of the world's foremost legal scholars. They're right at the top of the game. Therefore, I encourage you to read your cases and to read the other cases that become part of your research for the paper with that in mind. Looking at them as saying, how do they do it? How do they make a legal argument? Because they're really good at it. They're better than me, to say the least. Right? So look at what they're doing here as a model of legal writing. And take some comfort in the fact that you can greatly dial back the number of citations. Right? I've said 5 new cases. In addition, by the way, just an aside here about the new cases versus other cases, I just want to really hammer this home. I think I covered this earlier. Right? If you're making an argument where Campbell is really helpful to you, also cite Campbell, even though we've assigned it in class and it doesn't count as a new case. If you're using one of the later cases that comes after Kelly v. Aribasoft, this is one of the older ones on the list, and Kelly v. Aribasoft is actually helpful to you, cite Kelly v. Aribasoft. Because if it's helpful to you, you should use it. You should use it. the 5 new cases requirement is just a minimum to make sure you're doing some new research. After that, you should be worried about writing the best paper possible. And few of you will be able to write the best paper possible without citing some of the cases that I've assigned. But again, look at these folks as a role model. Read your case thoroughly, and look at it. But then also try and figure out how you're gonna talk about the same case without reproducing the judge's writing. I hope some of you are already starting to think that a little bit, like, wow, this is great, but how do I do this without plagiarizing the judge? Right? Anybody starting to have that thought a little bit? You know, fantastic. This is awesome, Bill. This is super helpful, but the judge is going to make all the arguments. They're going to cite all the cases. What do I do? That's a good question. The answer is not to invent a 5th fair use factor or to cut one out. The answer is not to decide that your case is not a fair use case when it really is a fair use case. The answer is not to stay away from the judge's reasoning, but the answer is to look at the core of the judge's reasoning and decide whether you agree with it or disagree with it, and then decide how best you can make your claim using your own reading of the law, including especially the cases that came before your case. So if you pick Kelly v. Aribasoft, it's a great case. I love Kelly v. Aribasoft. If you pick Kelly v. Aribasoft and write your paper, and you talk about commerciality under the first factor, maybe going immediately for this quotation from Campbell v. Cufferose, not such a great move. Right? You're probably going to want to say that commerciality is not the death knell to fair use. Even if you're saying that it isn't fair use, that's something you should probably at least concede. And the definitive case for that claim is actually Campbell v. Cufferose. I'll just tell you that right now. That's the definitive case for the claim that, for the point, which is true, that it's that it's not an instant death for a finding of fair use just because the use is commercial. Right? But can you find another relevant quotation from Campbell to say that? And then explain that using different words than the judges use here. Find another case since Campbell that uses or maybe find another case since Campbell that uses the same, that comes to the same conclusion but uses different words. And then quote that case instead. So I'm not telling you that the wheel needs reinventing. I'm telling you that you have to reinvent the wheel because I want you to prove to me that you can build a wheel. It doesn't. The case is here. It's great. It's great. It's done. They wrote a good opinion. They make a good argument. I think they're very persuasive. I want you to prove to me that within the standards of really good undergraduate, high-level undergraduate term paper writing, that you can do the same thing. So wait, there's a question?
Well, I was gonna say, I was just writing down what you were saying about how to reproduce the judge's opinions. I know there's obviously also the option to you have to quote it to use quotations and then explain it.
Do not. Okay, here's another aside, which is really important, and I'm going to step back just to make sure this goes in the microphone. Do not quote from the opinion of the case that you have chosen. Do not quote from the opinion of the case that you have chosen. You can quote lower court opinions, but I want you to come to your own conclusion based on the evidence that was available to these judges when they made their conclusions, which didn't include their opinion. They had to make that. I want you to make your own opinion based on the evidence that was available to them at the time of this decision.
My other question is about the citation. I know online you can just Google like MLA format and it'll tell you, that they're all different from newspapers or wherever it came from. Obviously, magazines. But considering that we're using LexisNexis and it tells you all of those, is there?
You do not have to follow all of the in fact, it would probably just clutter up your bibliography to follow all of the new MLA requirements that you identify in detail where online you got something. I'm going to know that your cases came from online.
Yeah.
Right? Just tell me the citation for the case, and I'm going to know that it came from LexisNexis. You can even skip the part where you tell me that it came from LexisNexis.
Yeah, I was going to say because they're all on your website.
Yeah.
Most of them.
So your case citations in your bibliography should look like this. That's all I need. I've already given you 6 good examples of what a case citation looks like to the extent of the detail that I need. Right. Party A versus Party B, the primary citation style, which is the number US number F.2D 3D number F sup number, right? Just that citation style. And then if it's not a Supreme Court case, what court heard it and what year was it decided? That's it. That's all I need. That's all I need. And that's whether you're doing footnotes or MLA. Good question. Thanks. There's another way that you're gonna find that I've forced you. I don't force you, but I strongly encourage you to pick an organizational style, a means of organizing the paper that's gonna make it a lot easier to not plagiarize the judge as well, which is laid out in the paper in the paper assignment. Your paper should contain an introduction, conclusion, and 3 main points. 3 main points. Now, the first main point is the first main point that every judge, every legal paper about a specific case is always the first point, which is what are the facts of the case? The who, what, where, when, why. Right. And so that, naturally, is actually going to be the hardest part not to plagiarize the judge's decision on, unless I were to say, also make you do some research, not of the legal variety, but of the factual variety. Some news accounts about your case. And that's why I have the research requirement for 5 news accounts as well. 5 news stories, or print news stories. Now, for a few of you, even a couple of the cases on the suggested list didn't really get a lot of news coverage, and so if you can't find 5 sources that way, you can actually fudge a little and have 2 or 3 of your print news sources be law reviews. And those law reviews are going to have their own recounting of the facts and how that happened, and then you can quote from them and cite from them, and that'll give you some different language or different ways or different details you didn't know about. So here, this should also not be a plagiarism of the case, right? This right here, section 1, all 5 of your news accounts, your published news stories, should appear in this section, should be cited in this section. There should be in-text parentheses identifying all 5 of your sources in this section for most of your papers, A few of you will have 3 or 4 here, and 1 or 2 in the introduction and/or conclusion, and that's where they went up. That's okay. That's okay. But the purpose of that part of the research assignment is to make it so that you have something else, some other way to learn about the facts of the case other than what the judge tells you.
Okay, so like I said before, LexisNexis does show you the print resources of newspapers where it came from, but the last time I did a paper, I went to the library and they had like something where you could go there and like review the old newspapers there. Isn't that the same thing as doing it with LexisNexis?
It's the same thing. You're talking about handling physical newspapers?
No, like it was in a database, and I could like go through like actually view the pages.
Oh, the microfiche.
Yeah.
Like a digitized
You had
microfiche.
to find it through LexisNexis.
Yeah.
And you could go and then find it through the
Yeah, or another indexing service.
right.
Yeah.
But
Yeah, you shouldn't have to do that. You shouldn't have to do that. Do not, by the way, do not give me 5 news sources that you got on Google. Do not give me 5 news sources that you got on Google. Right? If it's a pretty obscure case that not a lot of people talk about, 1 or 2 from the general web, okay, I can live with that. There's an if in that statement. If it's something that's hard to research in the LexisNexis newspaper database, in the magazine database, right? And if it's a couple. One of the easiest ways to signal to me that you didn't put a lot of thought and time into this paper is to give me 5 news sources that show that you spent an hour on Google. You spent an hour on Google. That's actually not even that helpful because most of these are old enough that we have a problem of link rot. Link rot is when websites go away. That web address was good 6 months ago, a year ago, 2 years ago, but it's not good today. Right? None of these cases are from 2 years ago. They're all older than that. And so the web is actually not an especially helpful way to research what happened with them. A good, careful, scholarly archive of news sources is a good way. Is a good way. Okay, so that's the first point, facts of the case. That should be fairly straightforward. Obviously, you're going to want to focus on the facts that are relevant, that are relevant to the case, that help us decide, to go side with the plaintiff or the defendant. Facts that don't really weigh on whether we side with the plaintiff or the defendant, like where a company is based. Not important. California, Massachusetts, Georgia, I don't care. Right? Give me details that matter to the case. Now, here's where things are different. Here's where things are different relative to how most cases, most opinions are written, and relative to how most law review articles are written as well. Which is that I want a structural separation where you review prior cases and don't talk about your case. In a section where we just do that. I want you to prove to me that you can go do legal research and understand, again, in most cases, what fair use means, but understand the relevant area of copyright law based on what the prior cases say. Based on what the prior cases say. And I make you give me your own give this its own section. I don't really make you, but I basically say you should do it this way. Because it adds a level of structural separation to make sure that you're doing this basic step first before you then go applying those prior cases to your specific set of circumstances in your case. When you review the prior cases separately, then you've got that in hand. You've got that done. You've got that accomplished. You've got mail. If you're taking notes with them, great. If you don't separate these, though, if you try and say, factor 1, here's what the prior case law says, and here's how it applies to my case. Factor 2, here's what the prior case law says, and here's how that applies to my case. Factor 3, here's what the prior case law says, and here's how it applies to this case. Right? That's actually more typical, that's actually more common for the type of writing you'll see in these decisions by the judges. You're going to see a lot more of that than you will this. This is fairly rare. But the reason I do it this way is because if I don't, most students don't do enough of this before they try and apply it. Most students don't do enough development of the previous cases before they try and apply it. It's just not something that you've been taught to do well enough that it's a habit to do it thoroughly before you try and apply it. You think you know what effect is because I've told you what effect is. You think you know what amount is because I've told you what amount is. And then you just try and say, well, in this case, the amount looks like this. And we wind up with the argumentational equivalent of my Venn diagram up here. Right? Which is great. I want you to bring in those types of sort of applied intuitive understandings, but I want it to be grounded. I want it to be based. I want it to draw upon the prior case law. I want it to draw upon the prior case law. If I were to write a paper arguing that Ice Ice Baby is fair use, I'd have to talk about transformativeness in this way. I really would. I'd have to talk about transformativeness in this way. But it wouldn't be a very good legal paper if I did it that way without talking about the cases that have said that that's what transformativeness means. So I'd have to find the cases that talk about transformativeness in a lot of detail and find one or two to back up my claim that transformativeness is not evaluated based on how much is the part that is taken changed, but how different is the whole new work relative to the whole old work. So that actually would be kind of a fun project. I don't know what that case is off the top of my head. I'd have to go digging. Again, I've read enough cases. I know that that's what that says, but I'd have to prove it. You take my word for it because I'm a professor, right? But if I were to write the paper, I don't expect a reader to take my word for it. And don't expect me to take your word for it. Find the cases to back up those types of claims. Some of you may find it beneficial, actually, to think about and even start writing Section 3 before you write Section 2. Some of you may find it beneficial, helpful, to think about it and even start writing Section 3 before you think as much about it and start writing Section 2. And that's because the conclusions that you want to make in your case have to be based on the law, which means that you should be looking to introduce the law, the relevant areas of the law, the case law in particular, that best help you reach your conclusion in Section 3. Right? That should shape what you're doing in Section 2. That should shape what you're doing in Section 2. So if I'm running a case, so the Kelly versus Aribasoft, for those of you who are going to take this, now I'm going to get like 9 Kelly papers. For those of you who choose Kelly v. Aribasoft, I've already given away a very, very important part of this case, which is that a large section, a very important part of Kelly, in my opinion, is is it transformative enough relative to the commerciality, right? The commerciality hall pass of Campbell, right, opens us up to being able to ask, is it transformative enough to get us something new that's socially valuable? You're going to have to look at the cases that support that. Campbell, we know, right, for the commercial part, right? But what is transformative in Kelly's case? What is transformative? Clearly it's not quotation and paraphrase and criticism, No, it's a database. Is an indexed, indexable, searchable database, is that a transformative use? Maybe. You're going to have to find some cases that shed some light on what transformative use looks like in some slightly atypical ways. Thankfully for you, the judge is going to have lots and lots and lots and lots and lots of suggestions about where to look. Right? Infinity v. Kirkwood, transmission over telephone lines, UMG recording versus MP3, reproduction of audio CD into computer MP3 format, right? Los Angeles News Service, reproducing news footage without editing the footage was not very transformative, right? So let's imagine you want to be contrarian and argue that Aribasoft is actually infringing, which is the opposite of what the judge has held. That's great, by the way. I totally encourage you to think about taking both positions. Don't just assume that you're going to take what the judge says. Think about which side you want to pick and make that a conscious choice. So let's say you wanted to say, well, Kelly's right, Aribasoft is wrong, this actually was infringing. Here are 3 great cases that would help you make that claim. Because these uses, retransmission of a radio broadcast over a telephone line, right, reproduction of an audio CD into computer MP3 format, right, and reproducing news footage without editing the footage, those all look a lot like a search engine database, right, with images to me. Those all look pretty similar. And in those cases, we've got infringement, infringement, infringement. Or at least leaning towards infringement because not transformative. I don't remember each of these cases well enough to say for sure they're all infringement. So you've got a lot to work with here. You've got a lot to work with here. And if all you do is write a really good, clean paper that finds the 5 most interesting cases that your judge cites and writes them up really well, and also draws in the prior cases that we've assigned in class that are really relevant to your case, and writes those up well, and then applies them beautifully to your case, you're already at about a 90. You really are. You really are. Can you explain the facts really well? Can you, give me a good organization? Can you maybe draw in a case or 2 that your judge didn't find, doing some additional legal research? Great. We're in even better shape.
Can you go back to LexisNexis page and show us how you would maybe find a print source by going through the online source, like an example of how? Because I'm just trying to figure out in my head how to do that.
Sure. But I'm going to hold off on that. In fact, we've only got a few minutes left, so I really want to talk about a little bit more about how to find legal sources here, because anybody who works for Hunter and is in the library any day of the week can teach you how to do that. But here, what I want to do is suggest some of the ways for you to find cases that are relevant to your case that aren't necessarily cited in your judge's case. So again, like I said, if you're going to do Kelly, the commerciality aspect is going to be something that's going to be of interest to you, and you're probably going to want to talk about that in some detail. Now here, they're totally happy to say Campbell, Campbell, Campbell. If you reproduce the same quotation and say Campbell, Campbell, Campbell to talk about commerciality, we're starting to head south of 90, right? So what I would suggest that you do instead is to take the 510 US 569 citation, go back to the beginning page, and instead of the easy search page here, and now let me zoom out, go US Legal, Federal and State Cases, we're going to search for this specific citation, 510 US 569, in everywhere. Now, keep in mind, we're not going to do like we did at the first page where we plunk this in and say, I'm looking for this case. That's not what we're doing here. We're using this citation as a search term in other court cases. This is the citation for Campbell versus a cuff rose. We're going to use this as a search term to find other cases that cite Campbell. Now, it's real easy to find cases that cite Campbell, but I also want to be able to use that as a search term combined with other search terms. So, and commercial And I think it's star. So there's always an operator you can put at the end of a word to say, I want any word that starts with this and ends however, commerciality, commercialism, commercially. Right? So anywhere in the case that cites Campbell and anywhere in case that uses the word commercial. Now, LexisNexis has something really handy as a drop-down menu. Everywhere here, this is going to produce a bajillion results. How about at least 5 occurrences? So I want a case that really talks about commerciality and commercialism in some detail. All available dates. Because it's only going to be after. You know what, actually, though? We're going to do it for Kelly, so we want to make sure it's before. Let's say it has to be 2001 or earlier. 12/31/2001. So it's going to be between Campbell and when Kelly got decided. Now remember, I don't want you citing cases that came out after your case. I want you making reasoning based on the evidence that was available at the time your case was decided. "73 cases. Do I expect you to read and memorize and understand 73 cases just to answer this one part of this one factor of fair use? No. But you see how not difficult it is, how reasonably straightforward it is to start finding additional cases that talk about relevant areas in the law. In addition, and a number of these are going to not be cited in the Kelly case. So you're writing the Kelly paper, you're like, oh, I want to find cases that are not just cited in the Kelly opinion. Boom. There's a whole bunch of them. That same basic strategy can be used over and over and over again to find different topics, different areas in copyright. And so this is going to be SunTrust v. Houghton Mifflin, right? A&M Records v. Napster, et cetera, et cetera, et cetera. We've got some really interesting cases here, and you're off to the races. Have a good evening, and I will be posting this video on Vimeo like I did before, and then posting a link to it on Blackboard, and I'll also figure out a way to say a bit more about the readings.
Question.
Just a second.